let's get smashing. Patriarchy is a social system in which males hold primary power and they predominate in roles of political leadership, moral authority, social privilege, and economic control. In a patriarchal system, only males are actually guaranteed full rights of citizenship. Currently, in the United States, only males are explicitly protected under our Constitution. Everyone else is subject to legalized and government-sanctioned discrimination. So, the ERA, the Equal Rights Amendment. It is a proposed amendment to the United States Constitution that is designed to guarantee equal legal rights for all American citizens regardless of sex. It seeks to end the legal distinctions between men and women in terms of divorce, property, employment, and other legal matters. It says, in Section 1, equality of rights under the law shall not be denied or abridged by the United States or by any state on account of sex. So what would the Equal Rights Amendment do? It would give us equal protection, for one. The ERA would provide a clear judicial standard for deciding cases of sex discrimination. Not every state in the United States has ratified the Equal Rights Amendment, and therefore federal and state courts are inconsistent in their rulings regarding sexual discrimination claims. The ERA would help clarify sexual discrimination jurisprudence. Recently, Supreme Court Justice Antonin Scalia scared everybody just a few years ago by reminding us that there is no guarantee that women's rights will be held up in Supreme Court. He said that's what legislators are for. So if we want to make sure that our equal rights are guaranteed and protected, we have to get the states to do that. It's not guaranteed in the federal court. There are laws that do protect women from gender-based discrimination, but court rulings over the years since their passage have created legal precedent regarding on how these laws can be interpreted and enforced, often to the detriment of what the laws were really intended to protect women from. And again, they vary from state to state, from jurisdiction to jurisdiction, and there's no clear federal standard. Without the Equal Rights Amendment, gender-based discrimination is becoming harder and harder to prove in a court of law. Until the United States Constitution is amended to explicitly state that equality of rights cannot be denied or abridged on the account of sex, then the political and judicial victories that women have achieved over the last 2 centuries still remain vulnerable to erosion or can be reversed at any time, now or in the future. And they can be interpreted differently, enforced differently, and reversed at any time. The Equal Rights Amendment, they say, is needed in order to prevent a rollback of women's rights by conservative or reactionary political votes. Congress can just overturn it with the majority vote at any time, so it's not really guaranteed. Therefore, many of the current legal protections against sex discrimination can be removed even with the margin of a single vote. While courts in the near term would still apply skeptical scrutiny to laws that differentiate on the basis of sex, the precedents could still undermine them or eventually ignore them in the future by conservative or reactionary courts and court justices. So keep in mind, there's already members of Congress who have been trying to cripple Title IX, which requires equal opportunity in education. That's been going on. There's members of Congress who... You glued your fingers together? Now, examine the members of Congress who have been trying to cripple Title IX, which requires equal opportunity in education. Remember the ones who opposed the Violence Against Women Act recently, the Fair Pension Act, and the Paycheck Fairness Act. Examine the members of Congress who recently voted to pay for Viagra for servicemen, but they still at the same time oppose funding for family planning and contraception. Examine the members of Congress who have recently and for decades blocked the U.S. ratification of the United Nations Convention on the Elimination of All Forms of Discrimination Against Women. Most laws that discriminate explicitly against women have been removed from the books. Oh yes. The current legal and judicial system, however, still have an impact on women that works to their disadvantage. Because those systems have traditionally used the male experience as the norm. Therefore, lawmakers and judges must be encouraged to include equitable considerations of female experiences as they deal with issues of Social Security, taxes, wages, pensions, domestic relations, insurance, violence, and more. Without an Equal Rights Amendment providing motivation, the status quo will change much more slowly, if not get rolled back. Additionally, by passing the Equal Rights Amendment and protecting all citizens from discrimination regardless of gender, the ERA would improve the United States' standing in the world community with respect to human rights. Other countries have passed such language into their founding documents and constitutions, and so at some point they expect the United States to be able to do the same, to have the same equal standing with other governments. The governing documents of many other countries affirm legal gender equality. However imperfect the global implementation of that ideal may be, it is still at least in their constitutions. The Bill of Rights and other constitutional amendments, where would the ERA fit in with that? Well, the first 10 amendments protect our freedoms of religion, of speech, of the press. They protect our rights to bear arms and the rights of the accused. They protect us from having soldiers stationed in our homes and from unreasonable searches and seizures. Further amendments end slavery. They ensure citizenship for freed slaves and the rights to votes for all citizens, among many other things that we have amendments for. Guaranteeing equal rights and equal legal protection for all citizens regardless of gender is currently not among them.